this is our lawyer Valeria Buzaker, and my role in the office, I'm a paralegal and also the legal business development manager. So today we're going to do a presentation here. So first of all, this is the disclaimer. So it's just for your knowledge. This is the information contained in this presentation does not constitute legal advice, and the information made available in this presentation and form is for general information purpose only, and an accuracy and currency of information, and also no lawyer-client relationship. It's just for educational purposes only. 所以说这个 presentation 呢，就是主要是关于就是没有只是作为一个只是作为一个演讲，然后没有任何的就是承担一些法律上的一些责任。那首先就介绍一下我们的律师事务所。那我们是布扎克律师事务所。So here again, the presentation is only intended for educational purposes and do not replace any independent professional advice. OK， 那就关于我们，那我们是布扎克律师事务所。那布扎克律师事务所呢，致力于为我们客人及社区呢提供最真挚、专业、高品质的法律服务。那从了解阁下以及您独一无二的需求和目标开始。我们为每一位客人呢提供绝对的私人定制服务。那秉承着建立并增进深厚客户关系的服务理念呢，我们运用扎实的专业知识和丰富的实战经验，那帮助阁下的利益呢达到最大化。那我们拥有来自一支不同文化背景的团队，提供英语、国语、希伯来语以及俄语的服务，然后为您的工作、为您的沟通上呢带来最大的便利。那我们的 location 是在180 Steeles Avenue West， 然后在非常的这个 location 呢非常的便利。那门前呢有大量的停车场。然后我们的服务范围呢是房地产买卖，就是民用地产和商业地产。那我们最擅长的是就是民用地产的同时呢，我们最擅长是商业地产。为什么呢？因为我们而且毕竟是主要是做那个企业商务法，所以叫商务法。那其次就是各类移民和遗嘱公证。
Bobby,
yep.
I'm sorry. I think someone doesn't speak Mandarin here, so maybe you should do.
So someone doesn't speak Mandarin? Oh, sorry. Okay. So the service we have is residential transactions, and then we have residential and then commercial commercial transaction as well, and then we more expertise in commercial, and then also because we have the business law, and also we do immigration, and also the wills and the notary public. So this is our scope of services. And so the previous one is the locations. So this is English, okay? Thornhill, and then so. I'll just maybe just give you like an English introduction. Sorry, I didn't know you. And 那首先介绍一下我们的律师，我们的律师是Valeria Buzaker。那呢，他是一位资深的商业及地产律师，持有加拿大和以色列2国律师执照。那曾任德勤 Deloitte 法律项目主管，那拥有15年的跨国经验。那他又是加拿大多元文化商业理事会会长，他热心社会公益，在犹太和及俄罗斯社区呢享有很高的声誉。So our lawyer Valeria Buzaker, and she's very experienced business corporate and real estate lawyer, and then she possesses Canadian and then Israeli lawyer license. And then she was a former legal project coordinator at Deloitte, and also she has like 15 international experience. And then she's the president of Canada Multicultural Commercial Council, and then she's devoted her time in the a lot of community activities, and she's very reputable in the Jewish and Russian community. OK， 那么就接下来有请Valeria 为大家做一下今天的 presentation. Back to the stage.
Thank you, Bobby. So I don't speak Mandarin yet.
Yeah. Okay. Yes.
Yeah. Okay. So we send this one. Okay. So we were thinking what to talk about today, and we decided that the most common and interesting part is the clauses, because this is what you usually have on a daily basis. You have to draft those area forms, and you have to know what you're doing and how you do it. So obviously, you know, you've been in the course of real estate. There are plenty of pages and pages and pages of different clauses. We chose a couple of clauses that we think are important to be paid attention to be known, to be used. Okay, so the agreement is determining the client's rights and obligation throughout the transaction, and after closing, you would like to protect your clients at all stages of the transaction, including all the due diligence and addressing all the title issues. So we're going to talk in details about all of those things. This is just the introduction, but I do want to mention recently, especially with all the market right now, a lot of real estate agents are very eager to close transactions, and sometimes you're signing the agreements too fast. It's very, very important to do the due diligence properly before you sign the agreement. Clients are still the same clients. The stress is even bigger because they cannot get mortgages and they don't know what's happening. It's very, very important to understand what your clients needs and what they are buying. I had my client's situation where they purchased a house where they had no idea. It's their first time home buyers. They bought a house in Kawartha Lakes. They thought that they are buying a residential property. They had no idea that this is an agricultural property. The problem is that when the agreement is firm, there is not much that we can do. Please make sure that your clients understand what they are buying. I would even sign them on some papers, making sure that they understand what they are buying, and make sure you ask them all those questions. Okay, so you are buying this property. What is your plan? What are you going to do with this property? Because after a year, after 2 years, after 3 years, you will be facing a claim where the client will be unhappy. And this is actually what happened. The client will be coming after you and saying, well, I didn't know what I'm buying. You never advised me that this is an agricultural property. This is just one example of something that can happen, because this client purchased this house not because he wanted to live in Kawartha Lakes all his life. It's because he didn't have enough funds, and it was a cheap investment for his purposes to occupy the property, and this is what he purchased. So the fact that someone is buying a house or wants to buy a house in Kawartha Lakes, you do have to do your due diligence and ask the clients all the questions. Why are you buying there? Is this because you want to live in Kawartha Lakes? Is this for investment purposes? Are you going to build houses on this property? It was a 27 acres property. So there is plenty of land there to do some work. Now they cannot do this work because it's an agricultural property. So it's not in the presentation, but it's a case that happened to me last week with my client, and I wanted to address it because it's very, very relevant, especially now. Okay, so what do we have in the agreements? So in the agreements we have the irrevocability period, which I hope everyone is familiar with, is by when the offer can expire. The importance of the requisition date is something that I want to stress, because often I receive agreements after the requisition date, which doesn't give me an opportunity to send the requisitions to the other side. I hope everyone is familiar what is a requisition date. Anyone is not familiar that I need to elaborate? Everyone knows what it is? Okay. So requisition date is a very important date where we search the title. If we are after this date, we cannot search the title. So unless there is something which is really, really major that is going to influence the title, we cannot change anything. We cannot request from the other side to do anything. So 3 weeks ago, I had a transaction where I received the agreement after the requisition date. There were 2 restrictions on title. They were not influencing the title, but they were too restrictive. And because their acquisition date already elapsed, we sent the letter to the other side requesting to delete those restrictions, and he said, sorry, sent it too late, there's nothing we can do. So now my client has to remove it himself. He can do it, but it will cost him more money, the client is unhappy, and etc. You can join us. So this is why it's very important. You always want to keep your clients happy for sure, for all times, for future reference. Searches, it's very, very important to make sure if there are any specific searches that are required to do on the specific purchase, whether you're the seller or the buyer, make sure you have the relevant clauses for that. Not searches that we perform as lawyers, I mean any other related searches. Fixtures and chattels is very, very important to make sure that you fill out this clause. Many times I receive the agreements with empty lines, which is very concerning because the clients say, but it's in the agreement. They don't read. When they sign the OREA form, they're so stressed, they just want to sign the agreement. They don't read. And then they come to me and say, well, it's in the agreement. Yeah, I opened the agreement, nothing is there. So it's very, very important to know what they're buying, what are the chattels that are included, because later on the closing date, all the stress is coming out, they're calling the agent, where is my fridge, where is my stove, and they took everything because it wasn't in the agreement, right? So it seems like it's very obvious and simple, but I see it on a daily basis. And I pick and choose the couple of clauses which I see repeating itself. Okay, so I kind of came up with a couple of questions that are only my recommendation. I definitely suggest that you will have your own checklist of questions that you will ask your client. So you know who is your client, what is he buying, why he came to you. I gave you a couple of ideas of what to ask because those questions are never asked, usually. I mean, they're not so common, so on purpose I chose a couple of uncommon questions, such as, do you have pets? Why a real estate, come join us. Why would a real estate agent care about if your client has a pet, right? Usually you don't. I mean, you cannot ask all types of questions of your client. But this may be very, very important because if he's buying a condominium or he's buying a townhouse in the condominium structure, maybe his pets will not be allowed because the bylaws, you cannot, they say specifically in the bylaws that you cannot have pets. And maybe your client is a breeder. He's making, the dogs, like he's producing the dogs. This is his business. And I have a client actually like that who lives in an apartment building and he is a breeder. So it sounds as if it's obvious, but it's not. It can definitely dramatically change the decision of your client if he wants to buy this house or not. Do you want to do any renovations, any new floors, any plumbing, kitchen? So again, if it's, for example, a condominium, usually renovations are not allowed. Even if it's actually townhouses, it's something which is very interesting because more and more because of the market that the prices went up, a lot of clients cannot afford buying houses anymore, detached houses, and they buy the cheaper versions of townhouses, and they try to buy the cheaper version of the townhouses, which is the condominium townhouses. And they are not aware. I have a client who has a closing next week. She bought a house, and when she came to me, she didn't understand what is a condominium. She gave me the status certificate, so I started explaining her, this is status certificate, it's a condominium structure. But when you see the house, the client who is buying a house first time in their life, they don't know that this is a condominium. They're buying a house, townhouse. Okay, so this is a house, that's it, it's my house. But suddenly you start reading all the 100 pages of the bylaws, which says you cannot do this, you cannot do that, make sure you get approved, you get the consent, and etc., etc. So those things are very, very important, and it's very important to be addressed to your clients because, like I said again, and I will say it 10 times, you want your clients to be happy. What type of window coverings? It's the same thing. Condo are very, very strict about the color of the window covering, which is only window covering. It's not even the furniture, but they don't allow. Some of the condominiums say, I want to see only white and gray color. That's it. This is what the bylaws say. So you don't need to sit and read the bylaws for your clients, for sure. We also don't read the bylaws because none of the clients will pay you or me for reading the bylaws. But I definitely tell to all my clients, and I put it in writing, that I advise them before any condition elapses to sit and read the bylaws so they know what they are purchasing. Another question, did you see any other units in this building? Make sure that they know what is in this building, if it's a building or if it's a structure. What kind of vehicle you drive. So this is a real case that also happened to me, where why would I ask my client what kind of a car he drives, right? So my client purchased a house, and it was a big house, 37 or 38 square foot, 38, oh my God, 1,000 square foot, huge house. And there were 2 parking lots, which seemed fine, big lot, everything seemed fine. And then what happened after they closed, after they moved in, they finished with the moving, apparently on the first floor they built a washroom. And when they were building the washroom, they took some of the space from the garage, and by that they made the garage smaller, shorter. So you can no longer fit another big car in the garage. Obviously a client who is buying a big house won't be very happy that he cannot fit the car that he drives, right? He's not going to buy a new car just because he bought this house. And he was very unhappy in the winter where it was snowing and etc. So those are small, I'm giving you only examples of small questions that can be asked and can change your relationship with your clients, because you will make them happy and you will find the proper house. You will take a look at from different perspectives, and you will make your clients to look at the house from different perspectives. Okay, so inspections. So this is one of the clauses which used to be relevant, then it stopped being relevant, and now it's relevant again. So now, again, we see more and more and more. I believe now it's 95% of the agreements I see include the clause of the inspection. And it's very, very relevant because it can change the price of the purchase of the house. The house seems fine. We had a closing, actually it's going to happen next week, where they were buying a house which was, I believe, 8 years old, which is pretty new. And they had the clause of inspection conditional. They performed the inspection and they found a lot of issues. So it was about total amount of $5,000. It's money. And they said, okay, we're not going to waive the condition until you give us a discount of $5,000, or I want to see it in the statement of adjustment. Eventually they did give them, it was negotiation and etc. But this is how your client can be very happy, because here we go. Otherwise, after closing, he find all those issues, he have to pay this $5,000. You will keep on hearing from this client on a daily basis. And I'm sure you want to move to the next client. So what is really important about this clause, there are a lot of variations of the same clauses that I see. So it's very, very important when you add some clause, you read the clause before, because many of the clauses you do sometimes copy-paste from previous agreement, and sometimes it's not applicable in this case. So this offer is conditioned upon the inspection of the subject property by a home inspector at the buyer's own expense, okay? So it depends again, who do you represent? If you represent the seller, you will definitely want to try to negotiate and include the buyer's own expense, and vice versa. If you represent the buyer, you would want to say, no, I want to have the inspection, but I want the seller to pay for it. Maybe they won't agree, but I'm just saying, read, make sure you negotiate it properly. And the obtaining of a report satisfactory to the buyer. Okay, this is very important, because it's not just having the inspection. The buyer has to be satisfied that this inspection was performed properly, and he doesn't want to request any additional discounts or negotiate any additional terms. And sole and absolute discretion. Okay, so this is very important. I saw many, many different variations of the same clause used differently. So just read your clauses. Searches. So I don't know how many of you are representing buyers who are purchasing one unit and multi-units. This is something which is very popular at least for my clients who are purchasing investment properties, and those investment properties may be 2 units, 3 units, 4 units. In this case, there are additional searches that are usually needs to be performed by us as lawyers. And we sometimes have issues with the other side when we represent the buyer, because in order to perform the search, we need the consent of the seller. The seller has to sign the consent. And this is why it's very important to have the clause which says the seller authorizes the we just gave you an example of a clause. Vaughan Fire Department to release the buyer or the buyer's representative or solicitor any and all the information that may be on record in the ministry's office with respect to the said property. Okay, so we gave you a template of a sample of one of the clauses. There can be many different, like I said, variations of the same idea. Just pay attention that if your client is purchasing more than 1 unit, if you're not sure, you can contact your lawyer and you can ask if there is any additional clause that needs to be added. Because if the lawyer who represents the buyer cannot perform the search, we cannot close the transaction. This is how bad it is. Because without this, for example, fire department search, we cannot order the title insurance. If we cannot order the title insurance, we cannot close the deal. We cannot have the mortgage, and etc., etc. So this is very important. And again, when the clients are cooperative, when the seller is cooperative, there is no issue with that. But unfortunately, not in all the cases, both parties are very cooperative. So your goal is to protect your client. And if you represent the seller, you would want to make sure, even if you, the buyer, but even if you represent the seller, you want this transaction to be completed and closed, right? This is your end goal. You're starting with the client and your end goal is to close the transaction. So try to help the transaction as much as you can. Now, a very important clause that happened to me several times, appliances as viewed. I don't know how many of your clients, but I know how many of my clients always make plans how they're going to take their fridge and their stove and their countertop and their microwave, because they chose this microwave for at least 3 years they researched. So this is the clause. The seller warrants that the appliances mentioned herein shall be the same as viewed by the buyer and shall be in good and working order at the time of the closing. Okay? So if your client is buying an expensive home and it has a sub-zero fridge, you definitely want to make sure that you include this clause, and you even would take some pictures to make sure that, or you write down the number, the serial number of this fridge or this stove or whatever it is. Because sometimes the value of those appliances can come up to $40,000-$50,000, which is a lot of money. And if you see Sub-Zero and then next day you see Waterloo, what's called? KitchenAid, whatever. Anyway, something with cheaper version. So definitely your client will not be happy, and it's not just not happy because it's very costly. It's a big difference in money. So you would want to make your client, even let the client take pictures yourself, make sure you write down all the serial numbers and you include this clause. And sometimes it's not only relevant in the more expensive houses, sometimes it's relevant in the cheaper houses as well. Again, it depends what your client wants to have or doesn't want to have. Rental items. So for some reason we don't see the clause here. I apologize for that. I brought it with me. But the bottom line, I mean, the clause is pretty standard. You have it in your OREA forms. The clause says the following equipment is, just an example, is rented and not included in the purchase price. The buyer agrees to assume rental contracts if assumable. So you make sure that you investigate if there are any rental items in the property your client is buying or selling, because in both cases you need to be aware of what are the rental items. Today you have more and more rental items. It can be anything, literally anything. Nowadays you don't know, so you need to make sure you ask those questions and you make sure that you have this information. If you represent the seller, to provide it to the buyer. If you represent the buyer, to make sure to request it from the seller. Okay, because first of all, the seller can suffer if after closing he didn't give the information. He still keeps on paying for those rental properties, because there is a form that needs to be filled out and transferred the rental item. If it's not done, then after 3 months, this is what happened to my client who, it wasn't on title. No one knew that it's a rental item. After 3 months, they contact him and say, well, why you didn't pay us for 3 months? What happened? Well, I sold my property, but no one knew about it, okay? It wasn't communicated. So make sure you ask those questions. It's literally gonna take you 60 seconds to ask the question, and they provide you with a form that needs to be filled out, and that's it. You have a question? Sorry. Okay, so like I said, ensure that the seller requests assignment of the rental contract before closing date and the purchaser reviews the terms and conditions, which is also important because sometimes when they review the terms and conditions, I had a client who was not happy and said, I'm not going to have this rental item in my house. I'm not going to pay $500 for a couple of months. This is not what I want to do. So sometimes you look for different options if maybe you can get out of this contract before closing so the purchaser can actually complete the transaction, everything is fine. There are many different options what can happen, but you need to be aware and your client need to be aware of what involves in the transaction. Okay, so with respect to as-is condition, it's very, very important because in many cases, you definitely want to make sure that you include this clause. The clause is a bit long, so we just put the important part. Purchase price, the subject property as it exists at the present time without representation, warranty, or condition with respect to the fitness, condition, value, zoning, or lawful use of the property. So for example, if we take my first example that I started with, where a client buys a small house in zoning which is not residential and you have this clause, you technically protected your client, who is the seller, because he said, well, this is what you're buying, as is. That's it. You cannot have any complaints after closing because you saw what you bought, you had your time, you could investigate. And my other recommendation, there are 5 different clauses for zoning. So if you're not sure, include another condition. Make sure that your client is satisfied before closing and not after closing when he wants to file a complaint. Include condition of zoning. Let him do his searches. Let him go to the city and request additional information. Because sometimes you think that if you give your client too much information, he won't sign the agreement. But on the other hand, if he does sign the agreement and he is not happy and he will file a claim against you, this is definitely not something you want. This sometimes can resolve the issue, because if you take this same client and you tell him, you know what, maybe you can buy a same idea property in a different place for the same price, but he will be satisfied with the zoning, you'll have a happy client and everything is fine. Again, it's your discretion, it's your clients. I'm just giving you my perspective because this is what I see on a daily basis with my clients, the agents I work with, and what they struggle with. So it's up to you, but I highly recommend that you investigate each case separately. So, like I said, even though the seller is required to disclose no latent defects, the buyer may face more problems during the course of repairs, which is another issue, right? Because if you see a house like that, you will have to do a lot of constructions and renovations in this kind of a house. You would want to make sure that you protect the seller, which will not be responsible if they find out about any other issues that the seller was not aware of, because this is what he is selling. Okay, so this is very delicate issue because we have a tendency, especially the real estate agents that I know, they want to help their clients in every way they can. They give them advices about everything in life. And they ask you tax questions, and they ask you design questions, and they ask you what should I do and how should I behave, and mortgage issues and whatnot. You have to understand that by giving them answers, you are liable personally for all the answers you give them. You do want to help your client, but you do want to protect yourselves, because sometimes the tendency of many professionals is to forget that they have professional liability, and by giving advice about something that they don't have the knowledge, they are liable personally. So this is a clause or a waiver that you can use, is an example. Like I said, the parties to this agreement acknowledge that the real estate broker so named in this agreement has recommended that the parties obtain independent professional advice prior to signing this document. The parties further acknowledge that no information provided by such real estate broker is to be construed as legal, tax, or environmental advice. So like I said, it's an example. You can put accounting advice, you can put whatever you want. But by putting this clause, you basically say to your clients, whatever I tell you, I am not a professional. I cannot give you tax advice. I cannot advise you with respect to mortgages. I'm happy to talk to you. I'm happy to refer you to the professional who deals with this profession. And by signing here, you understand that I am a real estate broker and or real estate agent, and this is who I am, and this is what I specialize in. And again, like I said, this is just to protect you. Leased property. So I'm not going to go into the landlord tenancy board. My goal is just to give you a reminder about all the changes in the legislation lately, and make sure that you know if your client is buying or if your client is selling. If there is a tenant involved, make sure that you refer them to a paralegal who specializes in landlord-tenant boards. You want to make sure that your clients know what they're selling, know what they're buying, because then all the issues come up on the closing date. Suddenly, the tenant doesn't leave the house. Then the purchaser buying a house with a tenant who doesn't want to pay him additional $500 because this is the prices in the market, because you cannot add additional $500 if until now he was paying $1,500. Then they want to sell the property, then they are angry, and etc. So you would also want to include clause which says, for example, upon acceptance of this offer, the seller agrees to provide the buyer with copies of all the leases of the property. Upon review by the buyer, determines if the terms of said leases are unacceptable to the buyer. Okay, so because you cannot refer your client to go to a professional advice without having all the documents in place. You would want to ask if there is any agreement between the landlord and tenant. You would want to make sure that the buyer is able to review those terms and provide it to any advice that he requires in order to make sure that he still wants to buy the house, or the seller is even able to sell the house, because sometimes you cannot get rid of the tenant, which is a big issue, because one of the clauses, as you are aware, in the OREA form says specifically that the possession of the house needs to be vacant. Okay, and they sign on affidavits which says that the possession will be vacant. If you cannot vacate the tenant, you have a big issue. It's a big lawsuit. So those are simple questions that can be asked, simple information that can be provided. You are not required to give them any advice with respect to all this information, but you are there to advise them what are the important steps that they need to take, what are the important documents that needs to be reviewed, and what they should do with those documents. Okay? So you can tell them it's very important for you to know if there is a tenant, to see the documents. If you're representing the seller, make sure that your tenant can leave the property, or make sure that the purchaser is actually wants to accept those terms and conditions between you two. Okay? Corporate client. So corporate client, it's a whole presentation by itself, but I think we have it in the other presentation, right? But I just want to touch it because I think it's very, very important. Many of you probably have clients who are corporate clients, not because they are major commercial corporate transactions. No, because it's a company, because their accountant advised them that it's recommended to open a corporation and do all their investments under the corporation. As simple as that. Maybe someone who is just an employee in some company and just want to do some investments. Now, when you have a client who is coming to you, let's say it's, I don't know, X is coming to you and says, hi, I want to buy a house. So your question number one needs to be, who is buying the house? You, and it relates to individuals as well. You and your spouse, you and someone else, you as a corporation. it's another question that most likely will not be asked, and I highly recommend that you will ask, because if this person is not actually buying this property as individual, but he's buying it as a corporation, you would want to do all the due diligence. You would want to make sure that he's a director, that he's an officer, that he's a shareholder in this corporation. You would want to make sure that he even authorized to buy in the corporation, that he can sign on behalf of the corporation. Because if he cannot sign on behalf of the corporation, all your documents which are signed has no force. This person who was just a friend of a friend who owns a corporation, even cannot bind the corporation, he cannot sign any of those documents. It's a big issue because you made someone to sign an agreement who cannot sign this agreement. So again, you don't need to give them any legal advice, you don't need to do all the due diligence yourself, but you need to ask the questions, and you need to ask them to provide the information to satisfy you that the person who is in front of you is actually going to buy the property. You can see like resolutions, but again, you can contact your lawyer, don't even go into all those details. But this is very important. Also, another thing that I'll just say, we don't have it in the slides here, but about franchise, for example. Sometimes you have a client who is buying, who bought a franchise and he needs to satisfy certain terms and conditions in the franchise agreement. You would want to make sure that the property that he is buying, he's even allowed to buy. Again, it's his homework. But just ask more and more questions and make sure you are satisfied with what you hear. Another situation which happens in life, right? Not all the people are alive forever, right? We have a certain limit. This offer is conditional upon the seller receiving the probate on or before X date or condition met or whatever you decide. Otherwise, this offer shall become null and void. So sometimes the seller is not actually the seller. Sometimes it's his father who passed away, or mother who passed away, or grandfather who passed away, or an uncle who passed away, and he's just the executor. You don't know. You literally don't know. So you need to ask, who are you? Who is buying? This is a question you need to make sure you ask always, always, always. So this is another example of why it's important. Maybe this person is not even selling the house. He was just named as the executor. Maybe they won't be able to get the probate done. If it's done in Newmarket, it can take 2 months. If it's done in Toronto, it can take 6 months. So if your closing is in 3 months and the person passed away in Toronto, what you're going to do? We cannot close the transaction because the probate was not done, right? So make sure you know who is the purchaser and, the seller, and make sure that if you hear something related to will, to probate, make sure to refer them to their lawyer so they know and they advise you that the closing can actually happen within the time frame of the closing date, and make sure you include the condition in the agreement so you don't have any surprises on the closing date where, oops, we cannot close. What do you do on the closing date? Okay? Okay, so assignments. Assignments is it's another presentation. But just to touch a couple of clauses, again, because of the market right now, because I don't know how it's with you, I don't know how many of you do assignments, but for me, I think now it became at least 30% of my practice because of the market. We always did assignments, but now it's very, very, very major because unfortunately many people cannot close their transactions because their appraisals are too low. They cannot get mortgages, they cannot close, they purchased houses and condos and whatnot a couple of years ago, and now they cannot close. They were notified by the builder that the closing will probably happen in a couple of months, and they're like, oh my God, what are we doing? So many of my clients are trying to assign, and many of my clients are the assignees. So, I don't know how many of you do assignments. So assignor is the one who is assigning his rights. The assignee is the one who is accepting the rights of the assignor. The assignor is the one who signed the agreement of purchase and sale with the builder. Again, of course, in assignments, we talk only about newly built houses and or condominiums. Assignment is basically an assigning your right to someone else by an agreement because you still do not own the property, you don't have the ownership on the title, you own the agreement and you own the money that you gave to the builder for starting the relationship and hoping to close one day and own this property. And for whatever reason you decide not to, sometimes it's not only for reasons that you cannot close, sometimes it's for reasons of just you found a better investment or you change your mind. I mean, we're all human, we'll make different decisions at all times. So the assignment agreement is drafted by agents, most likely. And it's very important to differentiate between assignment agreements, between regular agreements. They are completely different. Many different clauses has to be included. You have to be very familiar with the transaction because I hear a lot of things lately from clients who say, okay, we don't want to sign. What do you mean you don't want to sign? You already signed the assignment agreement, but we don't want to sign with the builder. But you already signed the assignment agreement that there are no conditions. That's it. Your deal is firm. Once your deal is firm, nothing can be done. We cannot amend the agreements with the builder. What is signed with the builder is signed with the builder. The only thing you can do changes is in the assignment agreement. The assignment agreement is negotiated between the assignor and assignee. The amount can be zero, the amount can be $50,000, the amount can be $100,000 for the assignment. It's up to you. Obviously, in addition to adding all the fees that were paid to the builder and etc. So it's very important to add the clause that it has to be reviewed by the solicitor of both parties, not assignee only. Because for many different reasons, actually one of them, yesterday I got a call from a lawyer who representing the assignor, and we put, the agent put in the original agreement, the assignment agreement, that the assignor's lawyer and the assignee's lawyer have 5 business days to review the agreement. And then these 5 days passed and the client signed a waiver. Then yesterday the lawyer calls me and says, well, I want to add one condition. What do you mean? You signed the waiver 2 weeks ago and there is nothing to add right now. Done. So make sure your lawyers actually know that they have those 5 days to review the agreement. It's another thing. Make sure you send it to the solicitor who is representing your client. So the clause, like I said, again, example, this assignment agreement is conditional upon approval of the terms by the assignee's solicitor or assignors or both, or I mean, there are plenty of clauses that can be used. Assignment fees. So this is something that you definitely want to calculate. So the assignor shall be liable for all costs up to the assignment completion date, and the assignee is liable for all costs and fees from the date forward. Okay? So why is it important? Because I see a lot of agents and clients, clients confused because of getting certain advice, where they don't understand what is the assignment closing date, what is the occupancy date, what is the closing date. And it's completely different dates. It doesn't have to be on the same date. It won't be on the same date. It's very rare where the assignment date will be the same as closing date. It can happen if you buy a house and your client is unable to pay for the assignment and he needs to get a mortgage. But you have to be careful. You have to know that if your client is buying a condominium, there is also an occupancy date in the middle. Okay, so you cannot promise your client that he will be closing the assignment on the closing date where there is an occupancy date. You have to know all the procedures, you have to know what is it involved, and this is why it's important. The assignment completion date is where both parties signed a 3-way agreement with the builder, and from this date on, they are responsible with the builder. There are a couple of clauses in this agreement where it says that if the assignee leaves the country, for example, or he's not completing the transaction, then the assignor will still be liable because the builder definitely wants to protect himself. So make sure you know the assignment fee. Make sure you know whether there is an administration fee involved or not. When I say assignment fee, I mean assignment fee from the builder, not the assignment fee that you put in the agreement of the assignment that your client, if he is the assignor, wants to get for this transaction. All those fees are related to the fees that has to be paid to the builder in order to complete the assignment transaction. So assignment fees, how much the builder wants to get for it. The administration fee is additional fee that he wants to charge. And developer solicitor assignment fee. This is not the solicitor who representing the assignee or the assignor. It's the solicitor who representing the builder. It's completely a different fee, has nothing to do with other fees. You have to be aware because sometimes it can be $10,000, it can be $15,000. And if the clients don't know, it's a very unpleasant surprise on the closing. Suddenly they say, well, we didn't know. Okay, well, you had to know. So I suggest you ask all those questions. I suggest you advise it to your lawyer that you investigated it. We usually give clients in writing advice. If we have the 5 days review to review the agreement, we put them a letter and give them in writing that we advise them that there is this fee and that fee and that fee, so there are no surprises. Not always we have the 5 days to review, so there's nothing we can do. So if you're not clear about those fees, I suggest you investigate and or give at least 5 days to the lawyer to review the agreement so they can advise the client. Assignment adjustments. So all amounts payable by the assignors to the vendor pursuant to the purchase agreement have been paid in accordance with the provisions of the purchase agreement. Okay, so this is very important because the fact that you see a list of amounts that were paid doesn't mean that they were actually paid to the builder. Make sure that there are no penalties because what many of agents do, what they contact the builder and they request a report. There is a report on file which says specifically a list of all the payments that were done to the builder, including if there are any upgrades, if there are any additional fees that were charged for whatever. Again, each project is very different, so we cannot include each case scenario. But just to protect you and protect your client, you can always request this information from the builder, so there are no surprises. You show it to your client, you say, here we go. Sometimes you'll be surprised, the assignor didn't pay. He sent a check and the check didn't get to the builder. Many things can happen. And suddenly, surprised, $20,000 were not paid. So if you represent the assignee, it will be a very unpleasant surprise where your client will have to pay additional $20,000. And let's say the assignor left the country, and what do? You file a claim against him for $20,000 and the assignor is no longer in the country. So protect yourself from any potential claims. Ensure that there are no monies other than the closing adjustments are owed by the assignor to the builder, such as upgrades. So as you know, I hope you know that on closing there are adjustments as well. So if we review the agreement from the builder, if the client brings us the agreement for the first 10 days cooling period, if it's a condo, then we advise them that there will be additional adjustments on closing. This is very important in the assignment transaction to advise your client that there will be adjustments. And it's very, very important to review those adjustments or any amendments in the agreement, because sometimes there will be an amendment saying that in case you assign this agreement, please be aware that the assignee will not be eligible for certain caps on levies, for example. And I've seen it many, many times. So suddenly your client will have to pay, if he's the assignee, on closing he'll have to pay, instead of $5,000, he will have to pay $10,000 adjustments. It's a big difference. Again, it's an example. It can be much more, much less, depends. So like I said, homework. Okay, I'm not sure do we have internet? Okay, so I have a short video for you, an example of a project that was canceled. I don't know if some of you had clients in this building. I had in an assignment, which was very exciting because my client was the assignee and not the assignor. And we closed the assignment 3 weeks before it happened. It was a lot of fun. My client was so excited. Yeah, so things like that happen. It's real life. It's no more books. It's what's happening in the market. Unfortunately, we cannot change many of the things. Hopefully, things will change in a year or two from now, but this is the situation right now. So this is an example of a clause that you can include If the developer is unable to complete the transaction by reason of default, the assignee shall not be liable for any damage or loss incurred by the developer, and this assignment agreement shall become null and void, and assignment consideration shall be returned to the assignee in full without deduction. This is so important because if you don't have this clause, the project is canceled, the assignment has to be canceled, and if you represent the assignee, you would want to make sure that the assignor has an obligation under the agreement to return the money. It could be $100,000, right? So make sure that you have this clause. So can we try to do the video? Hmm? I don't know. Microphone.
Link a link.
Yeah.
Yeah. There's a lot of people here. That's why. And you got them.
I'm not lying, I'm just saying what it is, right? This is from the news.
Yeah.
I didn't make this video. And this is actually to protect in the assignment agreement, right?
Yeah. So,
没有，有一个那个广告，它广告完了就可以。
Okay.
Looking forward to this for already 2 years.
One buyer after another in the same boat.
This seems very wrong to everybody who's planned their life around this development, thinking that Vaughan was going to be their new home.
People who bought into this condominium project in Vaughan called Cosmos. 2 years after putting down their money, buyers found out Thursday the deal is off, and there's nothing they can do about it.
The government has to get involved in protecting consumers from this kind of scam.
The project is walking distance from the new TTC Vaughan subway station. That fact in itself made this an attractive place to live.
It's a two-bedroom apartment for $385,000, so it's a pretty good deal considering real estate right now.
The company behind Cosmos, Liberty Developments, wrote buyers a letter telling them their contracts are canceled due to the inability to secure satisfactory construction financing.
They've manufactured a reason to say, well, it's not satisfactory, meaning it's not as cheap as they would like it to be. But that's a totally bogus, answer.
We went to Liberty to get some answers, but no executive would come out and speak to us. Can you set us up with a spokesperson?
Not this time.
And there's no way that people who could afford this property 2 years ago are able to make that investment now, given the circumstances.
Development in the area is booming. The Cosmos project was a sellout. Liberty had bought this adjacent property too. For now, all there is a pool of water. Buyers will get their money back without interest. They've lost a place to live and any appreciation.
Now we're, like I said, priced out of the market altogether.
Getting something else nearby will cost a lot more.
I didn't figure that a developer who's been around for 30 years would be able to just essentially tell me that they're no longer making this development.
It's legal, but it's clear that the law is not helping consumers. The law is antiquated. It didn't anticipate builders backing out for manufactured reasons.
1,100 units involved. And as he said, what Liberty Development did is legal under the current law. Nothing stopping the company from starting up a brand new project, reselling the same real estate at much higher prices. Given demand and that TTC subway, a strong possibility. This is what can happen when you buy a condo or a home before it's built. Those contracts are written for the developer's benefit, not yours. All right.
time. Okay, so hopefully you got some impression of what happened. I hope you didn't have clients in this building, and hopefully you are going to remember this case for your future transactions. And it's really very, very important to know what are the clauses that you include, especially in the assignment agreements. It's very important to understand the transaction because many of the clients, they need to assign. They don't have a choice. They cannot close and they have to assign. And they are very stressed. They just want to sign this assignment agreement. Okay, so finally we found someone who will take this from us, you know. And this is your job and our job as lawyers later to be uninfluenced and not emotional with our clients. And understand the situation and make sure that we protect our clients and we protect ourselves in those transactions as well as any other transaction. And in this case, it's also very, very important that you remember that you advise your clients in different difficult situations where the assignor is getting paid for this transaction, for example, and suddenly they tell you, oh, I don't like some line in the agreement where the agreement is already firm, and you remind the client, well, you're getting paid for this transaction. In today's market, you have to say thank you that you're able to assign even your rights. And to protect the transaction, because sometimes clients get very, very emotional about very strange things. I see it even very intelligent clients, CEOs in big companies, and suddenly when it's their own personal house, they're so emotional about very not important things. But this is our job to point them to the really important things and to make sure that these transactions are actually happening in their favor. Okay, so I brought you some example because many times I'm being asked of how you calculate the numbers. So this is how the numbers look like. This is the schedule that you usually include in the assignment agreement. Just gave you a very simple standard example. The purchase price, including the original agreement of purchase and sale, and the assignment agreement is $390. The purchase price of the original agreement of purchase and sale included in Schedule C is $350. So when the assignor signed the agreement with the builder, the purchase price was $350. The deposits that were paid to the builder is $70,000. Okay, so which means that out of the $350, $70,000 were already paid. Now, it means that if the original purchase price was $350 and the assignment agreement purchase price is $390, it means that the assignor is getting $40,000 from the assignment transaction, only the assignment transaction. Now, if $70,000 were already paid in deposits, you add to the $70,000 the $40,000, which means $110,000, which has to be paid on the assignment agreement, because the assignee has to cover the deposits that were already made to the builder, plus the assignment agreement. And the rest is like in any other transaction, the deposit under this assignment agreement. So when they sign the offer, they put a deposit of, let's say, $25,000, and then the balance on closing to be transferred is $85,000. Any questions about the numbers?
What about sometimes upside down? We bought assignment for $1 million and sold it to $800,000.
Sorry, say it again. If what?
There's some now.
It's the other way around.
The other way. It happens. It does happen right now. I mean, if they don't have a choice and they cannot close, So they will be liable for 1 million, or they will just reduce the price in 200,000, let's say. So they lose 200,000, but at least they won't be liable for $1 million claim. So it depends on each situation, case by case, right? So it happens because unfortunately, so the calculation will be different, of course, yeah, because someone actually asked me this question in one of the presentations, and they asked me, okay, so it will be minus? No, it cannot be minus because the purchase price is still the same purchase price, right? It's a matter of how much the assignor is going to get for this transaction. But the builder still has to be paid, and the calculations will be done in accordance to the amounts that are in this specific transaction. As long as you understand, I mean, it's really, really straightforward. But it's very important that you understand each line, because I don't know why, but I see many times agents who ask me about this schedule, what do I put in this line, what do I put in this line? So I thought, okay, let's bring this page, this schedule, so at least you know about all the lines. Once you know how to fill out this form, I'm sure you can handle if it's plus, minus, and the calculation. Yes?
My question is, back to the, so if you make a loss of 200,000 and he only pay, let's say 150,000 deposit, so it will be a negative of 50,000. So payment from assigner to assignee, that 110,000, if it become minus 50,000, it doesn't make sense.
It's not minus, then the schedule has to change in accordance to that. Then the assignee will, the assignor will have to pay the assignee.
Oh, the assigner pay the assignee.
Yeah, because if the closing is still not going to happen, I mean, I agree with you, it's funny, but it's very sad because this is what the market is right now, right?
Okay. Then it makes sense.
When they prepared this schedule, they were not prepared for this kind of situation, right? It's a standard form. Maybe OREA will decide to change this form one day, I don't know. Hopefully the market will change and there is no need to change the schedule, right? Yes.
So would it be better if we ask for the deposit for the assignment to ask the actual 70,000 instead of the 25?
It depends on the transaction. I mean, many times the assignee will not have the 70,000 right away. He wants to firm the deal. And if the assignor is interested to close this transaction, he will say, you know what, just give me 25,000 and that's it. As long as I know that the agreement is signed and the funds will be transferred in the trust from lawyers, right? The transaction is done with 2 lawyers. I mean,
Right.
I don't see any issues.
Okay, but then let's say because the mortgage environment get pretty difficult right now, right?
Correct.
So what's the way to protect the assignor then? You know, if they are putting so little deposit, how can we protect the assignor?
Well, he is protected under the agreement, right? The agreement still has to close. The assignment agreement still has to close. If he is unable to close with the builder, it's a different story. But the amount that he agreed to pay will still be paid on the assignment date. This is why I said it's very important to understand that there are different dates. There is the assignment completion date, there is the occupancy date in case it's a condominium, and there is the closing date of the house or condominium. It's a completely different date. This amount will still be paid on closing of the completion of the assignment.
Right. So let's say at the time of the closing,
Yes.
if the assignee could not get the mortgage approved,
Mhm.
then what happens?
If the assignee cannot close on the closing date,
Yeah, let's say they could.
then the assignor will be responsible in accordance to the agreement. This is the clause. This is the clause. I mean, usually the clauses that I have seen in the agreements I have seen, there is a clause which says specifically that if the assignee is not able to close, then the assignor is still responsible for the transaction. Now, what the assignee will decide to do, the assignor will decide to do with the assignee, he can file a lawsuit against him, etc., etc. But it's a different story. It's a litigation part, right? But the assignor is still responsible until the closing date, because the builder wants to protect themselves, right? Always.
So what happens if the assignee say they are no longer in the country? So because they make a loss, they say they are no longer in the country. How is the assignor going to go after that? You cannot have a lawsuit.
I completely agree with you.
And you cannot do anything. They can just
Yes.
walk away.
Yes. This is the risk you take. Life is full of risks, right? For better and for worse. Like I said, unfortunately, many of those situations are still not protected by law. Maybe, hopefully in the future they will, but right now this is the situation, yeah. Any other questions? I think we are done, so you can ask any of the questions you had, or if you want, I can go back to any of the slides. Because usually we have questions during the presentation, but yeah, go ahead.
I have a real case, actually. It happened recently.
Mhm.
The buyer wants to purchase a farm, and they signed an agreement actually 5-6 months ago. They experienced a lot of delay.
Mhm.
So, but both of them come to an agreement for this delay. So the final closing date is supposed to be July 30th.
Mhm.
But because of the money transfer issue, the money was delayed for 2 days, so the money comes to.
He couldn't get mortgage or funds. Mhm.
So the money come to Canada in August 1st. So the seller said, okay, I cancel the agreement. I don't want sale. So in this case, but.
It's a litigation. It's a litigation matter.
It's a litigation.
Oh, for sure. It's a breach of contract, right?
Sorry?
It's a breach of contract.
It's a breach of contract.
Yeah. So you have
But
to.
the thing that the deposit is already in the other lawyer's offer.
Yes.
So is the purchaser can get the deposit back, or it's litigation?
It's I cannot give you advice on that here, but you definitely need to refer your clients to a litigation lawyer, because it depends on the situation and it depends on the negotiation between the two lawyers. Sometimes it's possible, and sometimes you have to go through court in order to get the deposit. And again, I haven't seen the agreement. I don't know what it says. It depends on the clauses, and it depends on the ability of two lawyers to negotiate the deposit. I can tell you from my personal experience, it happened to me. We had to involve two other litigation lawyers because it was either we hired two other lawyers to win the deposit, or they go for a big litigation case. And eventually we did release the deposit, even though the agreement didn't state so. But it was really a matter of negotiation because it was so close to get to the courts. So it really depends on case by case.
Do you also do the litigation?
Litigation we don't do. No, we have a lawyer in our firm who does litigation, but I personally do not practice.
There's two HST involved in this assignment.
Sorry, say it again?
HST.
Yes.
So the assigned norm should pay for the HST which you get from the difference, right?
This is an accounting question. Some of the accountants say yes, some of the accountants say no. I am not an accountant, so I won't say who is right and who is wrong. Unfortunately, yeah. The HST is paid, assignee is paying in case of, again, we didn't discuss assignments in details, but hopefully you know that when you purchase from the builder, you have to pay the HST on closing if it's an investment property. If you're going to occupy the property, there is no HST payable. But in terms of the assignment, it depends on your accountant what he advises you. If the assignor needs to pay on his part, because there is an income, right? So some say you have to pay HST, some say no. I don't know what to tell.
What happens if the owner occupy, are you allowed to refund the HST?
So it really depends if you ask on assignment situation, because if, for example, the assignment is done, let's say 3-4 weeks before the occupancy date, then the builder has the discretion, full discretion, to tell you that even if you're going to occupy the property, you have to pay the HST on closing, and then you can apply for the rebate, which will take about 3 months to get rebate back. Same thing for rental property, but rental property, there is no other option. If you say that it's an investment property, you declare it to the builder, you just pay HST, and then you apply for the rebate. In terms of occupying the property, the difference is between regular transaction and the assignment transaction, and the time when the assignment is happening. If it's close to the occupancy date, most likely the builder will say you have to pay HST on closing, and then you have to apply for the rebate yourself.
So if after occupancy, then are you allowed to, what happens is after occupancy?
You can apply for HST. For rebate, yes, of course, you can apply, but you still have to pay it.
Also, if you do it after occupancy, then you have to pay HST and then you claim
You
it back.
usually have 2 years to apply for HST.
And then you claim it back. So you pay
Yes.
first and then you claim it back.
Yes.
Even it applies to the parents assign it to the daughters, is immediate family.
It doesn't matter. HST HST you pay unrelated who is transferring what. What you're asking is land transfer tax. If it's a gift, it's a different question. It's a different tax. HST is HST. HST is payable to the builder because it's a newly built transaction. HST is according to the CRA rules where when you pay HST, on which type of transactions HST is applicable, right? Any other questions? Okay, thank you for listening. If you have any questions, you have our contact information. You are welcome to email us, call us. We're happy to help. Good luck.